let's go ahead and call our Policy and Governance Committee meeting to order. I'm going to channel my inner Lisa since she's unavailable tonight. Our first item up is to approve our minutes from our last meeting, which was apparently back in April.
Been a while.
I'll take a motion.
I move that we approve April's meeting minutes.
Second.
All in favor?
Aye.
Aye.
All right, let's get right into it. This should be fairly quick. We have our first item is the policy primers of gender identity. That we had gender identity removed and now we're just putting it back.
Yeah, so our recommendation is to include gender identity back into those policies that you have attached there this evening. Our initial information from legal counsel and recommendations from the School Board Association had recommended removal of that. I think as anytime we get a legislative change, you know, people are trying to sort through and make recommendations to make sure we're following the law. But as we've continued to get guidance and some updated information, we now know it's not illegal to have those in the policy. So the one thing we'll just have to be clear with families and staff on is that it won't necessarily be supported by Iowa code, but I think it's an important piece for our school community in our LGBTQ plus community to make sure that, you know, we have that noted in our policy language. So our recommendation is that we return that to local policy.
Great.
Go ahead.
Matt, do we see any effect of the anti-discrimination or non-discrimination laws not being honored by the state anymore? Does that have any effect on what we're actually doing here?
Well, that's the piece where if there was a claim filed, Charlie, then it wouldn't necessarily be supported by code. And so when we originally talked about this, of course, you know, there's still things that were going to happen around, you know, if we would encounter a bullying harassment issue that we would sure investigate, or if, you know, people are just mistreating each other, we're not going to allow those things to happen either. But as far as specifically noted claim that then could be filed against Iowa code, it would not be supported by that. It does remain in our non-discrimination statement. That was one thing we never removed it from. So does that kind of help?
Yeah, so as I understand it, it would affect what a party could do after the district has made some decision about their complaint.
Yes.
But it would not affect what we're doing with the complaint.
Yeah, we'll still respond to the concern and address the concern. It's just going, like you said, kind of affect the pathway of how far that concern could escalate or what kind of code supports, you know, any type of supposed violation.
Okay, great, thank you.
And that one we will be taking action on.
Yeah, both tonight, you're
Yep.
going to see in a second reading format per se, and that we would ask for action on both of these later tonight in the regular meeting.
So we'll just go on to the number 2, which is the extra service employees policies. It's basically just policies around a unit of our people that
It is.
didn't exist before.
It is. Good evening. Our 400 section currently has a section about our certified licensed staff and then a section about our support staff. These policies add basically a third section that really kind of repeats some of those other policies, but it's about individuals that have extra service contracts inside the district. There's just been a lot of gray area for some of these individuals, and so we think it provides them clarity about their responsibility, clarity about their protections and their rights as employees, and it's we believe a needed step and also an important step for those individuals as well as for the district. I think we talked about these back in April. I've worked with Director Williams. We haven't gotten necessarily any substantial feedback for any of the changes. We've worked with the association as well as Nick and others on these, and so we feel comfortable with where they are this evening.
Okay. I did have, obviously we're not going to change it between now and the board meeting tonight, but there was a couple little typos in a few places.
Okay.
In 416.5. In the second sentence, it says, the goal of the formal evaluation of extra service activities employees is to maintain extra service activities employees.
Okay.
Who me? There's a lot of employees in there. So I'm not exactly sure.
Less, do with less of those.
And then, I'm not sure if this was taken from like IASB or however we got it, but in 416.6, there's a little add more
Oh, okay.
sitting there. So we either need to add more or take out.
Oh, yeah.
My guess is we just didn't delete that.
Yeah.
But then the one question I have in 416.9 and 10, it references specifically the extra service activities employees code of conduct. Does that exist?
Does.
It does.
It does. And it's not something that we've talked about, whether or not we're going to have it adopted into a board policy or board regulation, but that's a piece that our athletic directors in conjunction with Lucas and Nick have been working on. And so it's, I guess it's incorporated through reference through those policies, but it does exist. It's a new piece to be a companion for our student good conduct policy.
That's good. I just didn't want to be referencing something
Yep.
that
No.
didn't
Yeah, it's
actually
there.
exist. So, okay. Any other questions?
So
for
only
the
quick
director?
question about that code. So do they actually have to sign it?
They do.
Okay,
Yeah.
that's all. Thanks.
Charlie?
No, that's fine.
All right. So that one we will also take action on tonight. And
Yes.
I'm not worried about the typos, but
No.
if we can fix that.
Yeah, you could
I'm sorry
suggest,
about that.
approval with the, correction of the typos even at the table.
So then we have some new policy primers. I assume that all came from end of the session
They did.
Yeah.
stuff, so.
And so kind of our normal kind of onslaught here in the summer tonight for these is just a first reading. I'll point out a couple, but I know that you all have been waiting patiently for my annual legislative update next month, so I don't want to steal. all
Don't
that.
want to spoil it,
I don't want to
Chase.
steal that thunder, but that actually is the, kind of kidding, but I'll make that presentation to the full board during the public session at the first meeting in August, and so we'll go into some of these more in depth. But you see the changes listed in all policies. There's also a summary document there. A couple of the ones that really that of note, the changes to the bullying and harassment. The states changed the language in that policy. It's removed anything regarding the bullying or harassment having to be tied to a specific characteristic of an individual. And it's also made it clear that the activity has to be repeated. The guidance we've gotten is that, obviously the more severe, the less it has to happen. But they say that the change was intentional to make sure that that language was in there. Again, we'll talk more about that, but that's one of the changes that we saw. Another one that we're still trying to work through and get guidance from the state on is 402.02, the child abuse reporting. Hold on, sorry, is that the one?
That's the right one.
Is that the right one?
Yeah.
Where those investigations are now going to be handled by the Department of Health and Human Services, not the school district. Remember, we used to have you approve a level 1 and a level 2
Yeah.
investigator at the annual meeting. We'll no longer have to do that because those investigations will be handled outside of our jurisdiction. There are some things that we have to do immediately in terms of if there's an accusation, the staff member has to be put on leave immediately. If it comes back founded, we have to terminate the employee regardless of, the severity of that. And not necessarily saying that we would disagree with any of those, but now rather being left up to our own internal investigations and how we would handle it, it's being mandated. We're yet to have the rules from the state or the Department of Health and Human Services about what that process is actually going to look like. They have put a timeline on there that the investigations are supposed to be completed in 30 days. 30 days is a long time to have an employee on leave. But again, we are sending folks to training, trying to get more information on those pieces as we learn about them. And then on a more positive note, one of the changes we see included, we can talk more about, is some revisions to the chronic absenteeism policy or law that was put into place last year. They've gotten rid of the certified mail, which I didn't ask you for an updated number this year, but we calculated it as being pretty significant.
Yes, it was $40,000, something like that.
So $40,000 from the general fund that we were paying for postage So that's real money. That goes away. They've also given us more flexibility in terms of when a family would have to be referred to the county attorney. Now, we still have that requirement that we have to notify, but remember we had that confusion last year about every time somebody got a letter, they thought we were referring them to the county attorney. We still have to notify the county attorney, but then it was only after they were gone 15 days that we had to make that referral. Well, they've given us the flexibility now to make the determination of whether or not it's having a negative impact on the student's academic performance. And if the school determines there's not a negative academic impact, we don't have to make that referral. So it's nice to see a little bit more flexibility in that regard. They've also expanded the list of exempt absences to include attending funerals, weddings, military-related pieces that we were kind of all scratching our heads on last year. So an expansive list of excused absences, more flexibility in the referral to the county attorney. So we see those as positive pieces in this piece of legislation. Those are a couple of the highlights. I'll just answer questions that you might have on those or other ones. But like I said, I'm going to try to hit a lot of these in our presentation, but thought I would just point out a couple of changes.
So Chase, I think I brought this up again, but I don't remember exactly what context or before. I was at a meeting, I guess last summer, this summer, in which Laura Burgess was in attendance. And she was talking about that the referral that the district makes to the county attorney's office about students' absence includes a recommendation about what action that the county attorney would be asked to take. If that's right, I think her, if I'm remembering her concerns correctly, if that's right, then she was saying that the district's recommendation about what the county attorney is to do should be looked at more closely by all of us, because it would affect whether the county attorney was deciding to well, I can't remember. Frank, I can't remember the alternatives, but I can remember that there was a concern about the district's referral form can, if we pay attention, can be, the district can make it easier for, or less onerous on students to have their absenteeism pursued by the county attorney's office. Does that make any kind of sense?
If you want to start, then I can follow up.
Yeah, so you might remember we had the county attorney Rachel here at one point. It might have been, I think, the end of what would have been 2 school years ago, and she had talked about that the county attorney's office was switching their approach. And so instead of the county attorney's office doing further mediation, I think that they had recognized the school district by the time of referral has already done mediation to that point. And so instead they were shifting to a charge first type of approach. Now she talked about the ways that those charges are eventually, I guess, dropped or let go of, as long as the family agrees to, some appropriate steps to try to get attendance back on track, or that we see positive attendance. Now, while we can have overall conversations with the county attorney, it's ultimately their decision what they do with that situation once those students and families are not in compliance with the compulsory attendance law. So I don't want to say that's incorrect, as far as what was being shared, but that's not the way we've viewed our relationship. That our job is to refer those in violation of the compulsory attendance law, and then the county attorney steps in and chooses which approach they're going to take. Otherwise, of course, you could, I'm sure where you're going, Charlie, is right. There could be all kinds of bias into the situation about which ones are we deciding to say, hey, you should mediate these, and these families should be charged. And so our understanding is that their approach is really that once they're referred, they're going to start with a charge, and that's how they're going to work through the process. Anything I left out? No.
And the charge is against the parent.
Against the
That's
parent,
the one thing.
yes.
It's against
Yeah.
the parent, not the student.
So some concerns or feedback we have heard, right, is about some of our probably immigrant families, and are they knowledgeable about all systems and processes, when that is the case? And I'd want to let people know we have a lot of school staff involved in those situations, trying to still navigate that for the family. Our hands don't suddenly, get removed from the situation once there's a referral to the county attorney's office. So I'm sure there's, areas of improvement where, we can work on that. We actually have a meeting here with Rachel, the county attorney, Rachel Zimmerman, here before the school year starts to review how that worked last year, because that was really our first year in the new system, and to make any changes we need. But
I wonder if it'd be helpful if we, that is one of you, contact Councilwoman Burgess to see if she's, just so that we try to understand each other's opinions about this.
yeah, we're happy to do some follow-up, because I don't want people thinking we're using discretion
Right.
on how that's going. That's not our role in the situation from the way we understand it. So we can do some follow-up there. Yep.
I got a couple things. One popped up when you were talking about the 40202, the reporting, the stuff's taken out of our hands to a degree and what steps are being taken. Does that impact language in other parts of our policy or in negotiated agreements or anything else, like in terms of like appeals and grievance type?
No, well,
It should have flagged the appropriate policies,
Yeah.
but I think that's something probably in review we'll have to continue to look at if we would notice another policy come up
And
throughout
I
the year,
just hear
Sean,
like,
but, yeah.
just put somebody on leave and then if it's founded, we get rid of them. Like,
I
I
think
feel like
that's-
there's a whole lot of language in other places that talk about that sort of
right,
thing.
I think that'll be the impact, right, is that people won't, they can still appeal it, but the answer is going to be, look, this is dictated by code, and so we wouldn't have the discretion not to put them on leave. I'm not sure it would necessarily.
Well, I think that might be something we take on the future, at least in terms of P and G.
Okay.
I'll let you do your agreements, how you do it, but
Sure.
with P and G, we should at least look to see if we have language somewhere else that will then be contradictory. I don't know if there is,
Yeah,
but
that's a good point. I mean, a couple of the negotiated agreements, there's a couple sections that I think might not square with this.
so just something to think of.
Mhm.
And then the one question I had, the way 211 is the open meetings one, which I focused on it because, sure. But the way it's written, it says, the training must be completed within 90 days of a school board or special election or taking the oath of office. So which is it, 90 days of the election or 90 days of taking the oath? Because those two things don't happen at the
They are
same
different.
time. So what is my timeline? I don't know.
I'm not sure.
I mean, it's way too
Yeah.
vague to be the election. I
Right.
mean, we may want to look at trying to tighten that language up, because we don't even have certified election results, so to start a clock on the election wouldn't seem to make sense. So I would think it's really about taking the oath of office is where we'd want to set that, but that's probably a good question, Director Eystone, we can work on that.
There's still a number of unknowns around that policy and what the rules are going to be in terms of who actually has to take it. Is it just new board members, or if you're reelected, you have to take it again?
Yeah, we talked about that too.
And so I think they're still trying to get some clarity. The School Board Association is trying to get some clarity around who actually does that apply to.
Yeah, there was a lot of questions on that at the webinar,
Yeah.
the session. They were like, who does this impact?
The other ones that we'll talk about next week, now that you brought that up, Director Eystone, is, I think you all are aware, because we've had a couple of closed sessions, there are some changes around the language that the board has to use going into a closed session. And so we'll go over a couple of those pieces as well in August as we do the review, some of those that are germane to the board as well as the administration.
Any idea what the training will cost?
Did not ask, did not ask that.
I think it'd be fairly limited. I'm assuming the School Board Association is going to put something forward for us to have you guys do that, so I don't think it'll be high cost.
Any other questions on these policies?
No.
We're not acting on these tonight, so.
Correct.
All right, so agenda saying our next meeting is August 26th So we'll obviously take up these primers again and probably start with the 100s to start. a
Back
new-
to the 100s.
The 100s, and then probably also revisiting 200.3R1 at
Yeah.
that point,
Right.
yeah.
We took that one off today. All right, that's it.
Yeah, right.
Anything left for the fellas? Entertain a motion to adjourn?
So, second,
All in favor? All right.
aye.